Okay, we're getting into IEP season. Let's answer this question. Signing your IEP, the end of your IEP. Now, for those of you, you need to check your individual states, all right, because some of them are different. Most of the states are going to have this common theme, all right, and that common theme is that you attended and participated in the development of your child's IEP. It doesn't designate on there that you agree or that you disagree. It just is an acknowledgement that you participated and you were present at the meeting. And this is where I'm dispelling some bad information that tends to be shared broadly across the World Wide Web and in parent advocacy groups. And also among some teachers that somehow by not signing the IEP, that you're somehow vetoing, or it's an act of veto, or somehow you're stopping the implementation of the IEP if you don't sign. Guys, it doesn't do anything but make you look bad unless you live in a state that specifically allows you that, let's say, a cushion of a couple days to make a decision, and there's some extra steps. But those of you who live in those states, you know that because it's on your IEP page. Those of you that live in Texas, in Alabama, in Georgia, in Tennessee, in New Mexico, which are all the states where we have offices. Guys, you don't have any leeway to sit there and have this cushion. There are a couple states out there that, will have you, allow you to think about it and then sign it for implementation. But the purpose of the meeting is to develop the meeting or develop the IEP to reach consensus is what the threshold is. And consensus obviously is everybody needs to agree, right? Is that there's agreement, there's consensus. But at the same time, if you disagree with your child's IEP, that doesn't mean that you have veto power from it being implemented. Even if you disagree with it, it's going to be implemented unless you take some legal type steps. And those legal type steps are that you have to trigger your dispute resolution in the form of, let's say, a request for mediation or filing a due process complaint and putting in writing that you're asking for stay put. And stay put would mean that we put a pause on the implementation of this IEP while your disagreement with the new IEP that you developed gets worked out, either through mediation, through another IEP meeting, or through a due process complaint. But if you don't do anything, if you don't put it in writing and notify the school district that you're requesting stay put and you're triggering, let's say, a mediation or a due process, or you're requesting another IEP meeting, the school's going to move forward in implementing that IEP. Now, if you don't say anything, and let's say you're just huffy and puffy and you decide to walk out and you don't sign the IEP is going to keep moving forward, guys. They're going to implement it. They're legally required to have an IEP in place for your child on a yearly basis. Now, whether you agree or not, that's what dispute resolution is for. That's what mediation is for. That's what due process is for. That's what requesting another IEP meeting is for. You don't just get to sit there and say, well, I disagree, and then not do anything about it. And if you sit there and you go, well, I don't like to be confrontational, and I don't like to file due process, or I don't like to get attorneys involved. Yeah, I got that. I feel for you. At the same time, that's what the rules are, you see. You don't get to sit there and block the school because they're the ones holding the legal duty to provide your child with a free, appropriate public education. So yes, there are going to be some of you that you absolutely disagree with the development of that IEP. And yes, the school is now putting you between a rock and a hard place to where you have to make a decision. Either you're going to accept the crappy IEP that you disagree with and not do anything, which you still have your statute of limitations, meaning that you may not like it, but you're going to give them a chance to implement it. And then if it's a disaster after, let's say, a semester, then you can come back and you're still within your legal parameters to challenge that through the dispute resolution options of mediation, due process, or requesting another IEP meeting to get it changed. But let's say you're adamant. Let's say they were trying to change your child's placement. They're making big changes to your child's IEP. And you're like, this is not going to work. Well, guys, that's the position that the school puts you in. It's not optimal, and it happens. You're now in a point of disagreement. So at that point, you have no other choice. But you have to put it in writing, and you have to let them know almost immediately. Yeah, and so let's say you're at the IEP meeting and you disagree there, and you're like, this is a no-go IEP. Guys, it's at that point that you need to, on the signature page of the IEP, you still need to sign it. You still need to sign your name that you were there, you participated in the development of the IEP. Doesn't mean you agree with it. But then anywhere on that page where you see any kind of blank space, you need to physically write in the along the margins that you disagree with this IEP and that you do not agree with this IEP. Now you can either assert your stay put there. You could sit there and say, I'm requesting stay put, but understand what that next step means. You just can't write stay put and then not do anything. You have to take that next step. The school's not going to do it for you. Just because you write stay put, or stay put. You don't want to write stay put though. You want to write stay put. But stay put, you still need to take that initiative to then make the request for mediation, request another IEP meeting, or draft a due process complaint and file it. All right, you just can't sit there and go, well, the school knew. No, see, now you triggered it. You triggered it, you need to see it through. All right? The school, if they know that you are in disagreement with the development of the IEP, ideally they should be smart enough to request either another IEP or agree to do mediation. That's a smart play. All right, to try to work through those disagreements, because that's the whole point of consensus, is to reach it. You may not reach it here, but once everybody discusses it or does some more evaluations, you may reach it on the back end. But I have some very obstinate school systems out there that are like, the hell with you. And at that point, what they need to do, if they know you disagree, or if they know that you're not happy with a change in placement, then they need to provide you what's called a prior written notice. And that prior written notice is going to explain why they are moving forward with this action regardless of your position. That is called a prior written notice. And many schools, if they're smart, will put on there that you have X number of days to do something to trigger your dispute resolution options before this goes into effect. I think that provides a legal cushion for them, to where if you fail to act within that 5 days or 10 days, which is the average, then at that point, they're more than justified in moving forward, because they gave you that opportunity of 5 days or 10 days to trigger your dispute resolution options, and you didn't do it. If I was a board attorney, that's exactly what I would be telling my schools to do every time. Give them a little bit of time. Give the parents some time. But there are some school districts that are like, oh, the hell with you, we're going to implement it immediately. And in that regard, I think it swings some of the sentiment of a hearing officer over to the parents, because they weren't given an opportunity to work through the issues before the school moved forward, knowing that there was not consensus on the team moving forward with the implementation of that IEP. So sign the IEP unless you live in a state where they provide you the time to sit there and think about it. But most states know you are there, you participated in development. Doesn't matter whether you agree or disagree, it's just a consensus. If you disagree, you need to write on that page anywhere that there's blank space that you disagree, why you disagree, and if you want to try to stop it, then that's when you assert stay put. Not stay put, stay put. And as stay put, then what that does is that tables this IEP and will implement the last agreed upon IEP until you're able to work this out. But the idea behind the law, behind this safeguard, is that you work that out expeditiously, okay, and immediately.